Hello, everybody. Thank you so much for joining us today as we're experiencing just a couple of technical difficulties. So please just bear with us for a couple more moments. Thank you. Brittany Nichols, are you on the line?
I am. Can you hear me?
Okay. Yes. Britt Waterman, are you on the line?
Yes, I'm here.
Okay, great. All right. I think technical difficulties have now been resolved. So we're going to go ahead and get this kicked off. Again, thank you so much, everybody. I believe everything should be in functioning order here. You should be able to see my screen, and we are recording this session. So I think everything looks like we're good. I know people are still filtering in here, but we're going to go ahead and get everything underway. So thank you again for your patience. I know that getting into listen to this information is super important to everybody. So we have over 1,000 attendees registered for the webinar today. So one thing I'm going to point out is you can definitely feel free to enter your questions into the webinar box. However, our time is going to be very, we have a lot to go over today. So whether we're going to be able to get to many of the questions, we will absolutely do our best to get as many questions answered as we possibly can. But just please be patient with us. So a couple of things. Like I said, we will be recording this presentation. So it will be available via YouTube, and anybody that is in attendance will be able to get a copy of the webinar sent to them. Excuse me, I am losing my voice a little bit, so my apologies. But you will be able to get a recording. So if you need to give this to another person within your company, or you want to reference it later on, it will be available and it will be recorded. Another thing to note is that, so while we are hoping to be as timely with the advice that we're giving as possible, it's very likely that things could change just while we're on this webinar. This is an incredibly fluid situation, and so the advice and the information that we're going to be giving you today is current to the best of our knowledge right now. Just note that things are changing very rapidly, and a lot of this is new to us as well. So we will do the best we can to get through the information as it stands presently. Just note that things are changing very, very rapidly on this. So I'm just going to go through a quick couple of introductions, and I'm going to talk about myHRcounsel's services. And so just let's see. Is everybody is able to hear us, correct? I see a couple of questions about audio, but I don't believe that's a widespread issue. So if you are having issues with your audio, you may want to call back in and try the call in. So somebody's saying that they do have audio and that everything looks fine. So just let me know if you're having any issues with your audio. You may just need to try to hang up and call back in. I'm getting a lot of messages that it's loud and clear, and yes, we are talking. So again, if you're using your computer audio, that may be an issue, but a bunch of people are saying that everything is good. So again, you might need to try to call in rather than using your computer audio. You may be muted somehow. Okay, So with that said, my name is Janelle Stanton. I'm the Vice President of Communications with myHRCounsel. I'm also one of our attorneys as well. And so my job primarily is to put on these educational webinars for our clients and for prospects and anybody else that might be interested. I also do our marketing and other communications, business development, a host of different issues here. And then, so it looks like the audio is, again, just fine. It might be, if you're using your computer, if they have it muted, you might not be able to hear it. So another suggestion there. And then I'm also joined with by Brittany Nichols. She's our Director of Legal Operations. So she makes sure that our clients get the legal advice in a timely manner that we guarantee. She also makes sure that we're staffed appropriately, that our attorneys are knowledgeable. She writes tons of blogs on the coronavirus and COVID-19 issues here. So again, a super knowledgeable person to have with us today. And I'm also joined by Britt Waterman. She's our senior associate. She's a real heavy hitter when it comes to helping our clients and answering the tickets that come in. And she's also very well versed in unemployment, which is going to be super, super important for everybody to know about. So we're really lucky to have her to give us information about that as well. So I'm going to go through the agenda here really quickly. I know a lot of the questions that you guys have are about the new legislative updates, and we are going to get to that, but I want to make sure that you guys are aware there's some other things that we also need to be thinking about. So we're going to go through and talk about wage and hour issues. We're going to talk about the traditional FMLA and paid sick leave laws because there is still applicability with those laws. If you're a company of a certain size or if you're in different jurisdictions, those traditional FMLA and paid sick leave laws are still going to apply to your company. We're going to talk about unemployment insurance, so talk a little bit about unemployment issues. We're going to talk about layoffs, terminations, or furloughs, and the WARN Act. So talking about what the difference is between furloughs, layoffs, and RIFs, and then give a little bit of background about the WARN Act. We'll talk about ADA, the Americans with Disabilities Act, and medical information questions. So what type of information can you ask of those employees or applicants that you fear that may have COVID-19? Just get into more of that, and then we're going to end with the legislative updates. So like I said, I know I'm getting a ton of questions into the chat. We are going to hold off on that till the end, and if we have time, we'll address some of them. But at this point, I'm gonna jump right into the content here. So starting off with wage and hour issues. So this is a question that we've gotten a lot from our clients is, what happens if I'm forced to close my business? Am I required to pay employees even though I'm closed down? So the way you need to look at this is it depends on whether your employee is a non-exempt employee or whether your employee is exempt. So non-exempt employees are people that under the Fair Labor Standards Act are required to be paid at least minimum wage and are entitled to overtime pay. Exempt employees are exempt under the Fair Labor Standards Act, so they do not need to be paid minimum wage, and they are not entitled to be paid for overtime hours. However, to be classified properly as exempt, you need to meet a three-part test that the Fair Labor Standards Act set out. The first part is that an exempt employee has to be paid on a salary basis. So they have to be paid the same amount of money regardless of the quality or quantity of work that they perform. So if they do 1 hour of work in a week or they do 60 hours of work in a week, they get paid the exact same amount. They also have to be paid the proper salary, which was just increased as of January 1st to something in the order of $36,000. So they have to be paid at least that amount of money annually. They do break apart that number into weekly, bi-weekly, and monthly as well. And then the most important thing for classification of exempt employees is the duties that they perform. So in order to be properly classified as an exempt employee, that worker needs to fit the administrative, managerial, or professional duties test in order to be properly classified as exempt. So this is not an who's hourly, who's versus salary, but that's how most people think about this. So for your non-exempt employees, your employees that are paid hourly, that are subject to overtime, employers are not required to pay non-exempt workers for work that has not been performed. So if you are forced to close down your business temporarily due to COVID-19 issues, whether that is your choice or whether that is the government saying that your business is not an essential function such that you're required to stay open, for those non-exempt employees, they are not required to be paid for hours that they do not work, even if they were scheduled to work those hours. So there is a difference here between non-exempt and exempt, and I'll talk about exempt on the next slide. But one thing you do need to think about, especially for our clients that are in the state of California, if you have an employee that's on standby or some type of on-call status, that may very well be considered waiting time or reporting time for purposes of payment of wages. So employees that are non-exempt, that are on call or have to be on standby for some type of reason, you may be required in the state of California, for example, to pay those non-exempt employees for those hours. So again, just something to keep in mind. It is different for exempt employees. So exempt employees are, again, people who are exempt from the Fair Labor Standards Act, minimum wage, and overtime requirements. Now, this is going to be very specific. It's going to be people who are managers, for example, that customarily and regularly manage the work of 2 or more employees, that set or have the ability to hire and fire, things like that. I don't want to go fully into that because, of course, exempt employees, that could be its own 1-hour seminar here as to who is considered as exempt. But for those exempt employees, employers are not required to pay exempt workers for full week absences. So if you are closed and you are going to be not, laying off or terminating your employees, but you are closed, you do not need to pay exempt workers if they miss a full week of work. If an exempt employee, though, performs any amount of work during a work week, they have to be paid for that full week. Again, that's because the law says that exempt employees are required to be paid the same amount regardless of the amount of hours that they work or the amount of work that they output. So just be aware that if they miss a full week absence, that you don't have to pay them for that. Like I said, you do need to pay exempt employees for any work week in which they perform work regardless of the amount. And one thing that you've got to be careful here is deductions from pay. So there are some exceptions for when you're able to make deductions from an exempt employee's pay. One example is if an employee is absent for work for 1 or more full days for personal reasons other than sickness or disability. This is probably not going to apply in this situation, unless they're missing work for, again, some other personal reason that has nothing to do with sickness or disability. Another exception here is absences of 1 or more full days due to sickness or disability if the deduction is made in accordance with the bona fide plan, policy, or practice of providing compensation for salary loss due to illness. So if you are a company that has exempt employees and you already have a paid sick leave plan, and again, we are not talking about any of the emergency paid sick leave provisions here at all. This is just talking about how your business functioned up to this point in time. You can deduct for absences 1 or more full days due to sickness or disability. So if an employee misses time due to them being ill or disabled for some reason related to COVID-19, you can take deductions from pay from an exempt employee in that situation, but only if you already have an established paid sick leave plan. So again, this has absolutely nothing to do with, with the COVID-19, with the emergency paid sick leave. This is just as the law is stated currently. So just want you to be aware of that. Now, some companies are still choosing to continue to pay employees because of the unique situation created by COVID-19. A lot of companies are voluntarily deciding that they will pay employees for time off from work due to COVID-19 for a limited period of time to avoid, undue harm to their employees for something that is really entirely outside of their control. Some employers are deciding to provide a stipend that represents a smaller sum than what they would otherwise be paid in employment, again, just to help bridge the gap in that pay loss. So a couple of things to think about there. I know that that's not feasible for many companies. That would be just an absolute, killer on the liquidity of the business, and you don't have those funds. I totally understand that, but some companies are choosing to do that. One thing that you should also be mindful of is unionized employers. So if you have a unionized workplace and there's a collective bargaining agreement in place, that collective bargaining agreement may create additional obligations to pay for lost time under some circumstances. So be very mindful if you are unionized that you definitely need to make sure that you're providing pay in those situations. And again, short-term disability plans might cover sickness due to COVID-19. So a way to get employees paid while they're having to deal with COVID-19 might be through a short-term disability plan. However, employees should consult with those policies and provide the paperwork as needed. A lot of places, this is an optional benefit. Some employees may not have chosen to take it. If you're getting questions about that and you have a short-term disability policy at your workplace, I would definitely make sure that that you're providing them with the paperwork and the information for how they can file for short-term disability. So a couple of other questions, some of the frequently asked questions that we're getting here is, can I pay employees for COVID-19 related absences even if they are not entitled to paid sick or vacation leave or PTO? And the answer to this question is yes, you can do that. You can voluntarily pay employees even if they don't have other types of leave available to them. But if you do that, I recommend that you establish a pretty clear written policy regarding that and make sure that you apply it consistently. You don't want to give one employee pay that's not entitled to it otherwise and then deny that to somebody else, because then you could be looking at disparate impact claims. Another big question that we're getting a lot of is, can I provide employees with additional sick days or allow employees to go into the red on PTO for absences related to COVID-19? So the answer here is yes, you can allow employees to go into the red with regard to sick days or PTO balances. However, this can be a huge administrative hassle and could leave you holding the bag if the employee terminates while they have a negative PTO balance. The thing about it to think about is state laws are very different on whether you're going to be able to recoup that negative balance of PTO from the employee. States like California, you would not be able to get that money back unless you brought litigation against that employee. In other states, in order to make deductions from final wages, you would need to get the written consent of the employee before you can withhold a negative PTO balance from final pay. So again, be very careful. And one thing that we're seeing a lot of is many employers are drafting policies that grant employees an additional number of sick days for 2020 that can be used for COVID-19 related absences. So that is perfectly fine. And you could set that up where those additional sick days don't carry over and are not Excuse me. I'm sorry about that. I tried to mute myself before it happened, but excuse me, I sneezed. You could set that policy up where additional sick days don't carry over into the following year. That's something that you could definitely do as well. Another thing to think about is employers can enact a temporary policy to excuse all COVID-19 related absences, but just make sure that you're drafting that policy to be legally compliant and applied uniformly. And do I have to pay an exempt employee if the business is closed, shut down, or no work is available due to COVID-19? So again, if an exempt employee is not going to be performing any work in a work week, then you do not need to pay them. People get this work week, work day thing mixed up sometimes. The test under the FLSA is whether no work was performed for that work week, unless you can make deductions based on one of those exceptions, like if an exempt employee misses a full day due to personal reasons or illness. So if an employee is ready, willing, and able to work, but the employer sends the employee home, the employee has to pay that employee for a full week if the employee performs any work in that work week. This is not the case with a non-exempt employee, of course, but if they are exempt and they've even performed 1 hour or 2 hours, or if they performed a half day even, you are required to pay them for that pay. If an exempt employee chooses to be absent, so they self-quarantine themselves or they're too scared to work or things like that, you can only deduct for full day absences that coincide with the work week. So again, we're looking at it's a work week test, just to be very clear on that issue for exempt versus non-exempt. And so with that, we're going to move off from wage and hour issues, and my colleague Britt is going to take over and talk about the traditional FMLA and paid sick leave laws.
I'll just talk a little bit about the traditional FMLA and the paid sick leave laws that applied in different states, cities, and counties before the federal law was passed. So the traditional FMLA, originally that's still in place, applies to companies with 50 or more employees and covers employees who are incapacitated, meaning not able to work, not able to come to work or telework, because of a serious health condition or because they're caring for a family member with a serious health condition. With how this applies to COVID-19, what if an employee doesn't have any symptoms? If an employee doesn't have any symptoms, FMLA would not apply to that employee. And in any case, you should not count any absences due to non-symptomatic COVID-19 related absences against the employee's FMLA allotment. And we can see on the next slide. So many states, as many of you know, they have statewide paid sick leave laws in place. Cities and counties have their own. They provide paid leave to employees to care. Many of them have or almost all of them have paid leave to care for their own illness or a family member's illness. Some paid sick leaves in some states or cities and counties also allow paid leave where employees' children's schools or daycares are closed, or where there's a public health emergency. Again, not all state or city paid sick leaves, but some of them do contain that contingency. Of course, an employee who had the symptoms of coronavirus would be eligible for traditional paid sick leave under a state or city law, because that is their own illness and they are symptomatic. As far as a public health emergency, that would depend. Some states, I believe 48 states have declared a state of emergency. As far as cities and counties declaring public health emergencies, That's happening as we speak. More and more are declaring a public health emergency. If you have questions about, well, should this employee be entitled to use their paid sick leave? I don't know. Has a public health emergency been declared? I would err on the side of granting the paid sick leave to the employee. The consequences for denying paid sick leave when an employee is eligible are pretty serious. So in these during the COVID-19 pandemic, you want to be as flexible as you can be and interpret the law in the most employee-friendly way that you possibly can. So you can see the next slide. So the question, is COVID-19 covered by FMLA? Well, that's up for debate. Is COVID-19 a serious health condition? There's guidance from the Department of Labor saying that the common cold and influenza are not serious health conditions unless they cause incapacity, so a total inability to work or telework for 3 consecutive days, plus continuing treatment by a healthcare provider. A consultation with a healthcare provider by phone does not count. So if someone has, excuse me, the common cold, influenza, or COVID-19, they're showing symptoms, they have fever, chills, cough, they call the doctor, they say, I'm feeling sick, I'm not sure what it is, what should I do? The doctor says, get plenty of rest, drink a lot of fluid, and, stay in bed and take some vitamin C. That's not covered by FMLA. That's not considered continuing treatment by a doctor. It doesn't meet that prong of the test, and COVID-19 would not be covered in that case. As far as continuing treatment by a doctor, if someone was suffering COVID-19 symptoms, they were unable to work or telework for 3 consecutive days, they went to a doctor, they got tested, the doctor advised them to quarantine, that would be continuing treatment by a doctor. So in that case, they would be eligible for FMLA for the time that they were unable to work or telework due to their COVID-19 symptoms. So it is a little bit tricky as to whether COVID-19 is a serious health condition. It is going to depend on that the 3 days of inability to work prong, and then the continuing treatment by a physician prong. It has to be both. So how do and then the same would apply to caring for a family member with a serious illness. The family member would have to meet both requirements under the FMLA for it to be considered the family member's serious illness as well. So how do state and local paid sick leave laws relate to the COVID-19 related absences? I think I touched on that already. They, some allow for public health emergency absences, in which case that would be, for a shelter-in-place order, school closing order, being advised by a healthcare provider to quarantine, or having an employer say, you have to quarantine due to travel. Those all might be absences that would be covered under state and local paid sick leave laws. If the state and local paid sick leave laws have that provision for absences related to a public health emergency or school or child care closure. For the state and local paid sick leave laws that only allow illness or family member's illness as a reason for paid sick leave, you'd have to have an employee or a family member with COVID-19 symptoms in order for the state or local paid sick leave laws to apply to that employee in those states.
Thank you so much, Britt. One question we're getting a lot of, and thank you so much. I'm kind of, as my colleagues are talking, I'm scrolling through the questions. one thing that we're getting a lot of questions about is is documentation to prove the need for sick leave, and can you address whether they're required or are still able to request documentation for paid sick leave to prove the need for it?
You can request documentation, so it depends on the state, city, or county law. Many states have the requirement, not all, but many states do have the requirement that an employee must be absent for 3 consecutive days before an employer can request a doctor's note. So depending on the law in your jurisdiction, you can request a doctor's note when the law permits under state and local paid sick leave. Right now, I mean, the healthcare system is completely overloaded. And if you've got an employee who's absent and taking paid sick leave for 3 days for COVID-19 symptoms, requiring them to go and, sit in a waiting room in an already overcrowded doctor's office and take the time away from a doctor who could be seeing other patients just to get a note written, it's kind of unreasonable. If you've got an employee who's got COVID-19 symptoms, is seen takes paid sick leave, is seen by a doctor, consider accepting an email from a doctor, just a form, a visit summary from the doctor that gets automatically printed out when an employee has a doctor's appointment, a form letter, something with a stamp on it. I mean, something a lot less specific. I would really relax that requirement just because the healthcare system is so overloaded right now. So you still can request that doctor's note. I'd be flexible on that. And then with FMLA, as far as requesting a fitness for duty form, you do have to notify the employee. When you notify them of their FMLA, that the FMLA has been approved, you do have to notify them at that time that a fitness for duty note will be expected for them to come back to work.
Thanks, Britt. We're going to hand it over to Brittany now to talk about ADA and medical information.
All right, thanks Janelle and Britt. Not to confuse you, I am the second Britt on the call. And I'm going to start off talking about the ADA, which is the Americans with Disabilities Act. This has been around for much longer than these new laws that we'll be talking about a little bit later in this webinar. So you're probably familiar with the ADA. It applies to employers with 15 or more employees. Many states have little mini ADA laws that apply to even smaller employers. So be aware that this likely impacts many of you as employers. So the ADA prohibits employee disability related inquiries or medical examinations unless they are job related and consistent with a business necessity when an employer has a reasonable belief, which is based on objective evidence, that an employee's ability to perform their essential job functions could be impaired by their medical condition, or that an employee will pose a direct threat due to a medical condition. And based on guidance we have received from the CDC and public health authorities as of March 2020, the COVID-19 pandemic does meet the direct threat standard. They have said that community spread of COVID-19 and restrictions and closure orders that we've seen really nationwide support a finding that a significant risk of substantial harm would be posed by having someone with COVID-19 or even symptoms thereof present in the workplace at the current time. Now, this could change in the future as the CDC and other public health officials revise their assessment of the spread and severity of COVID-19. But for right now, it is meeting that direct threat standard. So on the next slide, what this means for you practically speaking, if you still are open and you have employees coming into the workplace, You will want to know basically what you can ask of your employees at this time with respect to their symptoms or illnesses. So currently, employers may ask employees if they are experiencing symptoms of COVID-19, such as fever, chills, cough, shortness of breath, or sore throat when they call in sick. All of that medical information must remain confidential, but you are allowed to ask if they are experiencing those symptoms. You can also take an employee's temperature currently. Now, taking an employee's temperature is considered a medical examination, but during this current pandemic, this is allowed. I would note, however, that the CDC and other public health officials have advised us that not everyone with COVID-19 will have a fever. So this doesn't necessarily tell you all that you need to know. And on the next slide, we'll go over a couple other questions. You are required, or you are allowed rather, to require employees with COVID-19 symptoms to stay home or leave the workplace if they're already there. This also helps you meet your duty to provide a safe and healthy workplace for all of your employees. So if someone is exhibiting these symptoms, they can be sent home, or if they call in saying they have these symptoms, they can be required to stay home. When an employee returns to work, you can require a fitness for duty documentation, but just like my colleague Britt said, as a practical matter, doctors and healthcare providers are going to be extremely busy during this crisis, probably for the next several months, I would presume. So consider accepting alternative forms of documentation like form letters or stamps or emails, all of those different things that Britt already mentioned. And on the next slide, ADA accommodation is generally not going to be required for COVID-19 as it is a relatively transient illness. However, it could trigger other health conditions that do qualify as disabilities under the ADA. So if someone has an underlying disability like asthma or even cancer or diabetes, any type of underlying illness, the COVID-19 virus can create complications there. So you want to be really mindful and allow accommodation as appropriate in those situations. And if you do have someone who has become exposed to COVID-19 or has tested positive for COVID-19, you should notify your staff of that positive COVID-19 test or other exposure, but you must keep the individual's identity strictly confidential. So no releasing names of who has been tested, because that is confidential medical information. And as is always the case, you want to apply and implement all of your ADA and other strategies consistently for similarly situated employees to avoid discrimination or disparate impact claims. And with that, I think I turn it back over to Britt.
Yes, I do have one point I wanted to raise just before we get into unemployment here, but it is not illegal to ask for documentation from physicians to prove that an employee has COVID-19 or is on a quarantine or is supposed to be isolated. We are not saying it's illegal to request medical documentation or certification. We're saying it may be impractical to get that requirement, get that right now. So it's not that it's illegal to ask for it. You just may need to consider relaxing your requirements for providing it or allowing an email or other forms of certification to suffice. So I just wanted to clarify that one point quickly. But yes, Britt, take it away with unemployment.
So now we're going to talk about unemployment. I think she mentioned at the beginning of the presentation, I love talking about unemployment. I am a former unemployment law judge, so unemployment insurance, all things UI are kind of my specialty. Just don't ask me to calculate your experience rating. That's why I became a lawyer, because I was told there would be no math. But everything else, I love to talk about and am happy to help. So right now, it's a very rapidly changing time in the world of UI. A number of states have enacted changes to their UI laws, and a big reason for that is because the Families First Coronavirus Response Act, which most employers are thinking about the Families First Act in terms of the emergency family medical leave and the paid sick leave portions of the act, and are concerned about those. There is a whole other portion of the act that deals with unemployment insurance and has awarded states $1 billion to help with unemployment insurance. Now, how unemployment insurance usually works is, in order to get money, for states to get money from the federal government to pay out benefits, states have to meet certain requirements. So states have to have, the federal government requires, if a state's going to get federal money, they have to have a requirement that if someone's unemployed, they have to search for work to get benefits. That comes down from the feds, and so all states have that requirement because they want to get that federal money. Another federal requirement that trickles down to the states is the waiting week. You apply for benefits, you wait 1 week, you don't get paid that week, your benefits kick in the next week. So right now, as part of this $1 billion package to the states, the states are, and there's a couple examples here. So Arkansas waived the requirement that applicants search for work for 30 days. So they're waiving the work search requirement. That's something that employers can do to collect part of this money that's coming from the Families First Act, is to waive the work search requirement or modify the work search requirement. Some are saying 30 days, some are saying 90 days, because no one is quite sure how long this period of unemployment is going to last. So different states have modified it differently. We have here that Massachusetts waived the 1 week waiting period. That's another thing that employers can do to get part of that federal grant, is to waive the waiting week period. So most states now, and it's like we've said, it's changing as we speak. Most states have waived that 1 week waiting period. So if you apply for unemployment benefits, you're not going to have to wait. Your unemployment benefits are going to kick in right away that week. And these are all things that are changing in response to part of that receiving that federal grant. Another thing that's changing, that a change to UI law that's part of the Families First Act, that some states have taken advantage of, is employers are seeing a relief from charges. So any COVID-19 related benefits that are paid out to applicants, employers' accounts will not be charged for those benefits. This is not in every state. Every state has not adopted this, but this is something that the Families First Act said, hey, this is part of our bailout. States, if you want help, we will help you out with this. We will help you out if you want to relieve charges on employers. And so some states did take them up on that and say, you know, if employees have COVID-19 related benefits, we will not charge those to employer accounts. So you can see the next slide. This is the Federal Emergency Unemployment Insurance Stabilization Access Act. This is again part of that Families First Act. This is the section on unemployment insurance. Another requirement, and these are this has nothing to do with getting the part of the grant. These are now requirements in every state that every state has to do regardless of getting the grant money or not. This is now the law affecting every state. Employers are required to provide notification of the availability of unemployment compensation to employees at the time of separation from employment. And also you'll see the third bullet point, excuse me, that has to do with the second and third go together. This first bullet point, so notifying of the availability of unemployment at the time of separation. Prior to the act, there were only 2 or 3 states that required employers to inform departing employees about unemployment. Now it's all 50 states. When you're laying off your employees, when you're terminating your employees, when your employees, if they quit, if they're separating in any way, you have to give them a notice saying you may be eligible for unemployment benefits and here's how to apply. Here's the phone number, here's the website. Some states have made model notices. Check the website for the unemployment insurance department in your state. Go to the website, check the For Employers button. If they have issued a model notice for this, you will see it, you can print it out, you will have to use it. If they don't have a model notice, just type it up. You may be eligible, here's the phone number, here's the website. But you do have to provide that notification when employees separate, regardless of the reason for separation. States now have to ensure that employment applications are accessible in at least 2 ways, in person, by phone, or online. They have to have at least 2 of them. During the recession, a lot of UI departments stepped up and added the by phone and online methods to handle the influx of applications during the recession. So most states already had this, but this makes it a law that that states have to have at least 2 out of the 3 methods for applicants to apply for benefits. And then states must notify applicants about the steps the applicant can take to ensure the successful processing of the application, and they have to notify the applicant if the processing doesn't go through. The phone number or the online system has to take the applicant step by step through the process, let them know when the process is successfully completed and their application has been submitted, or if something is missing or something goes wrong, it has to take them through that process. And let's see, so some FAQs. When do unemployed workers become eligible for unemployment benefits? When they become unemployed or partially unemployed. So partially unemployed has a different definition in every state. In Minnesota, partially unemployed is working less than 32 hours. So in Minnesota, the week that you work fewer than 32 hours, you may be eligible for unemployment. You also have to report your earnings. If you earn more than your weekly benefit amount, and this is in all states, if you work that week and you earn more than your benefit amount, you're not going to be eligible. But if you're in other states, I think North Carolina, partially unemployed means if you work fewer than 3 days. In California, partially unemployed means if you work less than full time. It's all going to depend on your state what partially unemployed means. But as soon as you become unemployed or partially unemployed, you become eligible for unemployment benefits right away. Won't all these unemployment claims impact my business negatively? I usually contest all terminated employees' unemployment claims. Well, like I said, there is the new package that is allowing states to not charge employers' accounts for these COVID-19 related benefits. Like I said, that's not in every state. You want to go to your UI website, to that For Employers section, and find out if there is an application process or a waiver request form, something that you have to file to not be charged for these benefits. if that is the law in your state. So I would recommend checking in with the department in that on that website, because there may be a waiver form you have to fill out to not be charged. It's not in every state. And if you contesting one of these unemployment claims is not like contesting a quit or a discharge for misconduct. If someone is out of work through no fault of their own, which if you close your business or if you do lay off some of your employees because you can't afford to keep everybody, they're unemployed through no fault of their own, and you contesting it is going to be not the best use of your time and your funds to contest that, because it's a very strong likelihood that they will be eligible for unemployment benefits. What reason should I list for unemployment to make sure my terminated employees qualify? Layoff due to lack of work. If that's the truth, if that's the actual reason. If there's a reduction in force, put reduction in force. If it's a furlough, put furlough. I mean, be honest about the reason. If it gives you the option of layoff due to lack of work, and that's what happened, usually what's going to happen is that application is going to go straight through. There aren't going to be any further questions, and the applicant is going to start getting paid right away. Sometimes the applicant will check terminated for another reason or something like that on their application. That's going to trigger a questionnaire getting sent out to you asking, well, what happened? What was the reason for the separation? If you get that questionnaire from your department asking, what happened, what was the reason for the separation, you should write layoff COVID-19 on that questionnaire. Send it back immediately. The longer you wait, the longer your employee has to wait for benefits. So, just lay off COVID-19, email it back or fax it back, whatever you have to do to make sure your employees qualify.
Awesome. Thanks so much, Britt. So we are, as per usual, we're running up against noon already. We have a couple more topics to touch on, so we are going to go over our appointed end time. Hopefully you'll all be able to hang in there with us through the end. If not, like I said, we are recording the webinar, and everybody that is in attendance will be able to get a recording of it. So if you have to jump off because of other meetings or phone calls, certainly feel free, but we've got two more, and I think very important topics to get through here. So one thing that we're getting a lot of questions about is furloughs versus layoffs versus reduction in force or termination. And so the terminology here is very, very important, because not only does it impact employee health insurance benefits and unemployment and applicability of the new laws that have come out, but it's important to get it right just so that your employees understand whether they're still employed and what the situation is. So with a furlough is considered to be an alternative to a layoff. So when an employer furloughs its employees, it requires them to work fewer hours or take a certain amount of unpaid time off. So this might be a situation where you have you've reduced an employee's work week to only 30 hours instead of their normal 40-hour work week, just because you have a loss of business and you don't need that employee working that full 40 hours. So if you furlough them and you say you're going to be working 30 hours instead of 40, that employee is still on your payroll. Depending on the way that your health insurance policy is written, they may still be eligible to continue your health insurance benefits. And like Britt was just saying, it's very possible they might be able to apply for unemployment to get some unemployment benefits to cover that 10-hour reduction in the work week. So a furlough is very, very different from a layoff or a reduction in force or termination. Some other companies will, say a furlough is to take a week or two of unpaid leave, but they keep them on the payroll. So for all intents and purposes, they're still employed. It's just that they may have a reduced schedule or a couple of weeks of unpaid leave. A layoff is also considered a temporary solution, but it is an actual separation from employment. So with a layoff, an employee is laid off because there's not enough work for that person to perform. However, the employer is thinking that once conditions change, they, are likely to recall that person when work becomes available again. So employees who are laid off are also going to be able to collect unemployment benefits. And again, there might be benefit coverage continuation under COBRA, or the health insurance policy may have a period of time in which employees can remain covered until they're available for recall again. So layoff, it's a different thing from a reduction in force or a furlough if you're saying you're temporarily separated from employment. A reduction in force occurs when a position is eliminated without the intent of replacing it, and it involves a permanent cut in headcount. So a layoff can turn into a RIF if you choose to reduce the workforce because you're not able to bankroll your operations, or there's a liquidity issue or things like that. So you might be terminating your employees. A termination, of course, they're going to be terminated, so they're going to be able to get unemployment or apply for unemployment benefits. They also are likely to be eligible for COBRA if you do maintain a health insurance program. So now the question of whether you should do a furlough, a layoff, or a RIF. So this is going to be solely contingent on your ability to continue to bankroll your operation. If you furlough employees, they remain eligible for benefits. They remain eligible for the emergency FMLA and paid sick leave laws that go into effect on April 2nd. If you can afford to furlough, and this is, those issues are not a problem, or if your employees can easily work from home or telework, you might not need to go through the process of doing a layoff or a RIF or a mass termination. So it really does depend on the current economic conditions that you are experiencing. And also, I know a lot of people got very nervous and they just said, okay, well then we're just going to do layoffs. The federal government is looking at putting in place provisions that would protect companies who experience financial hardship due to what's going on with COVID-19. So Britt's going to cover those things in just a few moments here. So just be aware that the government is going to step in with some SBA loans and some other things, and there might be state grants that you're eligible for that can help you cover payroll. If you do a layoff or a RIF/termination, those employees are not eligible for the emergency FMLA or paid sick leave benefits, and they may not be eligible to continue your health insurance benefits. Again, COBRA continuation rights may apply here, and you might have COBRA notification issues that you need to comply with. So you've got to look at your own health insurance policy and see how long employees are able to stay on an active status such that COBRA wouldn't need to apply. And a thing that I want to make sure that people are aware of, and I don't think this is going to be difficult to document, but being able to document the economic need to conduct layoffs will prevent a host of headaches down the road. So you want to make sure that it doesn't look like you're just, conducting a layoff so you don't have to comply with the new emergency FMLA or paid sick leave laws. I don't think people are really out there doing that, but those are federally protected rights, and you want to make sure that you can justify the need for conducting the layoff. I don't think that's going to be difficult given what's going on, but just a little bit of a heads up. And now we're running short on time, but I think it's very important to give you guys some information about WARN. The federal version of WARN applies to companies with 100 or more employees. And so if you're doing mass layoffs or mass terminations or a big RIF, you're going to have to look at whether WARN applies to your companies so that you need to know whether you've got to provide additional notice, because the traditional WARN Act says you have to give 60 days of notice to employees who are going to go through, if you're going to go through downsizing. Now, there's some exceptions here for unseen business circumstances or faltering company. So again, it's possible WARN may not end up applying. California did choose to suspend its own versions of their mini WARN in California based on the COVID-19 situation. So again, not enough time to dig into this completely, but I do want to go over some of these. So are employees entitled to the emergency FMLA or emergency paid sick leave if they are terminated? The answer right now, as the law stands now, unless other guidance comes out, is no. If they're no longer an employee, they're not eligible for the emergency FMLA or emergency paid sick leave. And I've seen this question a lot, but if a worker decides that they're too scared to come into work for some reason, and so they don't have COVID-19, they don't have a family member that has it, that's not a legitimate reason under the laws that are coming up that we're going to talk about. And so those employees also are probably not entitled to that emergency FMLA or paid sick leave. Should I tell employees that I will rehire them once this all has passed? The answer to that is no. Please do not guarantee future employment. We don't know how long this is going to last. We don't know how this is going to play out. You can encourage terminated or laid off employees to keep in contact, but don't guarantee return employment or any specific time frame. And then again, can I keep terminated employees on our health insurance plan? This is going to depend on what your health insurance plan says for who is considered to be an active employee. Some policies you might be able to keep an employee on through the full month following the month of termination. So if you terminate now, they might be able to get benefits all the way through April. It just depends on your plan. And a lot of this is going to have to end up going through COBRA. So if you are going to be laying off employees and they're no longer eligible for benefits, then providing those COBRA notices is what you need to keep in mind. So I want to make sure, again, I know we're so over time, but this is the next step that we're talking about here. My colleague Brittany is going to come on and pick this up, and we're going to talk about the new legislative updates.
Thanks, Janelle. So many of you have probably heard by now about the Families First Coronavirus Response Act. It's hard to believe that this law is not even a week old yet, with all of the media attention that it has received. So this is a very comprehensive bill, includes lots of different provisions, including some unemployment benefits that Britt talked about earlier, and things like school lunches and all kinds of stuff. But as relates to you as employers, importantly, there is an Emergency FMLA Expansion Act and an Emergency Paid Sick Leave Act. The Emergency FMLA Expansion Act creates one new qualifying reason for employees to take FMLA, and that is when an employee cannot work or telework because they have to care for their minor child whose school or place of care is closed or unavailable due to a public health emergency like COVID-19. This Emergency FMLA Expansion Act applies to employers with fewer than 500 employees. So basically, if you have between 1 and 499 employees, you are covered by this act. And I'll talk about some potential exemptions in just a little bit, but just consider that you are covered by this if you have fewer than 500 employees. Employees who have been employed for at least 30 calendar days are eligible for this new FMLA expansion. The DOL, the Department of Labor guidance, has clarified that small businesses with fewer than 50 employees will be eligible for an exemption from the leave requirements relating to school closings or childcare unavailability, where compliance with those requirements would jeopardize the ability of the business to continue. And I will talk about that again with respect to the paid sick leave and go into that in a little bit more detail. The emergency FMLA expansion, similar to traditional FMLA, allows for up to 12 weeks of leave for this new qualifying reason, the first 10 days of which can be unpaid unless you have an employee who chooses to use their accrued paid leave, which can include new emergency paid sick leave that we will cover next. After those first 10 days, your employees are eligible to receive 2/3 of their regular rate of pay based on the number of hours they normally work. If you have employees whose schedules vary significantly, you can take their preceding 6-month average, or if you have an employee who did not work for you over the preceding 6 months, you can use the reasonable expectation of their average hours at the time of hire. And then on the next slide, we'll talk about emergency paid sick leave. So similar to the FMLA Expansion Act, this applies to employers with fewer than 500 employees. And here, all of your employees are eligible, regardless of the days of service that they have completed with you. If they're your employee and they've been with you for 1 day, they could be eligible. This provides up to 2 weeks of paid leave, which for your full-time employees means 80 hours. And for your part-time employees, that means prorated based on their number of hours. And again, if you have employees with varying schedules, the same rules apply to calculate that we discussed under the FMLA expansion. So looking at their preceding 6 months or the reasonable expectation of their hours when you hired. And on the next slide, you'll see the qualifying reasons to take emergency paid sick leave. If your employee is subject to quarantine or an isolation order, if your employee has been advised by their healthcare provider to self-quarantine, if your employee is experiencing COVID-19 symptoms and is seeking a medical diagnosis. Those are all reasons for which your employee for themselves can qualify for paid sick leave. There are also reasons for which your employee can qualify for paid sick leave to take care of a family member. So if your employee is caring for an individual ordered or advised to quarantine, if they are caring for a child whose school is closed or their child care is unavailable due to the COVID-19, or if your employee is experiencing any other substantially similar condition as specified by Health and Human Services, the Treasury and Labor Departments. And this last bullet point is still really a gray area for us. We expect to see some guidance from these relevant departments about what exactly a substantially similar condition is. Right now, we don't know. The first 5 bullet points are a little more clear. And again, similar to the FMLA expansion, there is a possible exemption available for employers with fewer than 50 employees as relates only to care for a child due to a school or place of care closure, if compliance with that would threaten the business. Now, we don't know yet what criteria the Department of Labor will look to in order to determine if a business can adequately demonstrate that compliance with these leave laws with respect to caring for their child while a school or daycare is closed, how that would threaten the viability of the business. But the Department of Labor has said that it will be providing guidance likely in April to articulate that standard. So on the next slide, I think this is pretty clear. Employees will receive their regular rate of pay during paid sick leave while they're using the paid sick leave for themselves, and 2/3 of their regular rate of pay when leaving their paid sick leave to care for a family member or a child whose school is closed. And on the next slide, employers who pay qualifying sick or expanded FMLA leave will be able to retain an amount of payroll taxes equal to the amount of qualifying leave that they paid rather than deposit that with the IRS. So this includes what you would be paying in federal income taxes, your share and employees' share of Social Security and Medicare taxes. So the IRS and the Treasury Department are really trying to make this more feasible for employers to comply with the new leave laws by providing this immediate assistance for that additional cost. And on the next slide, there have been a number of bills proposed, one of which is called the Keeping Workers Paid and Employed Act. This really involves some small business assistance, providing loans to certain small and mid-sized businesses. These loans, if they are applied to keep payroll going, and if certain conditions are followed, there is some loan forgiveness written into this current proposed bill. Right now, this has not been passed, so it's a little bit speculative what it will look like in its final condition if and when it does pass. And on the next slide, there's some additional information about what this current bill is proposing. There have also been a number of stimulus bills proposed in both the Senate and the House that are proposing varying numbers of direct payments to most American taxpayers, anywhere between $1,200 and $1,500 per taxpayer and up to $500 per child. Several $100 billion to small businesses and several $100 billion in loan programs for businesses. So these stimulus bills are, north of $2 trillion in some cases. So expect that the legislature will be duking it out to hopefully get something passed that will help employers with these new economic realities and keeping your workforce in place. And we will keep you all updated on those bills as they're proposed, as they're passed on our website.
Okay, awesome. Thank you so much, Britt. So yeah, we have, absolutely a ton of questions here, and I know we're well over time. We'll hang out and answer some questions for a little bit here. We're just unfortunately not going to be able to get to them all. One question as I've been kind of scrolling through these that we've gotten quite a few times is, how does the emergency paid sick leave interact with a current paid sick leave policy that we have?
So the emergency paid sick leave is in addition to any company provided leave that you provide, as well as any state or locally mandated sick leave, depending on your location. And your employees can choose to first take this new paid sick leave before going in and using any other paid time off that they have in their bank.
Okay, another question that I've seen quite a few times is, people want to know if the emergency paid sick leave and FMLA expansion are retroactive. So if they had employees that were out, 2 weeks ago for any of these reasons, is any of this retroactive? And, I'll take that because unfortunately, no. We don't have any guidance that says that these are to be retroactive. These do not start until April 2nd. So neither of these laws goes into effect until that point. Another question, and this is going to be a good question for Britt. So first of all, are business owners entitled to receive unemployment? And second part of that question, should the business be applying for unemployment, or should the employees be applying for unemployment?
So whether a business owner is eligible for unemployment benefits for himself or herself is a very fact-specific, state-specific situation. It's going to depend on the state, what type of corporation, how much you were paid in the last 4 calendar quarters. It's going to depend on a lot of different things. So what I advise is if you are the owner of a business and you've been paying yourself and been paying unemployment taxes on the wages that you paid yourself, go ahead and file in your state and wait to get that determination back saying either you're eligible or ineligible. If it says you're ineligible and you don't understand or you disagree with the reason, you can always appeal that. But I would say because it's so fact specific and state specific, there's no one answer that I can give. So I would advise just going ahead and applying for that in your state. And as far as applying for benefits, that should be the employees doing that. There are questions that are personal to the employees that they should be answering for themselves. So employees should be applying for benefits on their own as individuals rather than having an employer do it.
Okay, and then another question we've gotten is, what is the website that we are referring to? So myHR Counsel has created an employer COVID-19 toolkit that has blogs, and it will eventually host also the recording of this presentation and federal updates. There's FAQs in there as well that we're constantly updating. And so the website is myHRCounsel.com/COVID-19. So if you have questions, you want to check that out. That website has a lot of information for both our clients and non-clients alike. There is also information on the website there. If any of you are looking to sign up for our service, you are able to access our team of attorneys on demand through our online Ask an Attorney portal. It's a per employee per month charge, so it's based on the number of employees that you have working for you. And again, it provides you unlimited access to our team of attorneys, policy drafting. There's a number of benefits that are available there for you. I know we've got several of our clients on the line right now who I think would attest that they're pretty happy to have this service as they're going through these very confusing times. So there's a number of resources out there. We would definitely, I would love to answer all of these questions. It's just, unfortunately, for time purposes, we don't have enough of it to get to them all. So my apologies, but I do want to thank everybody for jumping on to the webinar with us today. Again, these things are changing constantly. That COVID-19 webpage that we've put together has the most up-to-date blogs and resources for you. So please make sure you check that out. And you can also get subscribed right to our services right from that website. It's our Ask HR service to get compliance assistance from our team of attorneys. So I just want to thank again all of you for joining, and apologize for keeping you past the hour. Have a great day. Do watch for future webinars from us. As these laws change, we will be putting together webinars regarding the tax credits, about keeping your businesses funded. If you have questions about the new Small Business Association loans, we do have a team of attorneys that are very well-versed in collections and construction law. So if you have questions, if you're in the construction industry, about your force majeure or different contracts, again, we have a team of attorneys that are available to answer those questions as well. So look for other webinars from us. We will make sure to keep people as up to date as possible on this. So have a great day, everybody. Thanks to Brittany and Britt. Your expertise is very much appreciated. Have a great day, everybody.